Hey, so welcome. Um, my name's Chris Allen. I'm an attorney here in Alabama, and I'm doing a test stream here to just make sure that I've got all my ducks in a row as far as live streaming goes. It's going to be a little quick introduction uh, to DUI stuff in Alabama, and I'm going to be talking about implied consent, which is, I would say, it's a good gateway into talking about DUI. So, what is implied consent? Implied consent just means that as a driver on the roads in Alabama, it is deemed that you have given your consent to an officer who has arrested you lawfully for DUI, taking your blood sample, breath, saliva. There's several different things um, to find out your level of intoxication, and that's codified in Section 32, 5 192 of the Alabama Code. I'm going to put it on the screen now. Um, so it says, it's pretty straightforward. I mean, it basically says that if you operate a motor vehicle on the public highways, then you've deemed to have given consent to a chemical test pursuant to a lawful arrest. That means that they can't force you to take a chemical test prior to your arrest. They have to arrest you first. But if they have lawfully arrested you, then it is implied that you've given your consent already. Couple of things that means: can I refuse to take the test even though I've given my consent by driving on the road? The answer is yes. Yeah, you can refuse to submit to the test. If you do refuse, your driver's license is going to be suspended for 90 days by the Director of Public Safety. That's outside of whether you're convicted of DUI or not. That's just an administrative function of refusing to uh, give your sample of blood or saliva or breath or whatever. So that's a separate thing. That doesn't require you to be convicted uh, to get in trouble. In other words, that's not a criminal liability there. That's just an administrative function. Um, Additionally, this is one of those rare instances or occurrences where if you refuse to do something that would be incriminating, in other words, you say, hey, I have a Fifth Amendment privilege not to give testimony against myself, which testimony would include blood sample, breath sample, saliva sample. So I'm exercising my Fifth Amendment privilege to not incriminate myself. That's fine. That's good. However, if you do exercise your Fifth Amendment privilege in that case, it can be used against you in a court of law. In other words, they can, at your trial, they can say he refused, to submit to this alcohol test, and that can be used against you to try to get a conviction. They can say, well, if he didn't have anything to hide, he should have submitted to the test. It's one of those rare cases where that's okay. Another thing, Okay, so it's implied I've consented. I withdrew that consent by saying no after the arrest. I'm not going to blow in your machine, or I'm not going to allow you to take blood, whatnot. Is that the end of the story? Well, not necessarily. Uh, the officer can go get a search warrant, which can be signed by a judge. Um, a municipal judge can sign it, a district judge can sign it, a circuit judge can certainly sign it. The search warrant would be for your blood or saliva or something else. Um, at that point, you can be compelled to give a sample. You know, they can strap you down on a gurney and take your blood if they want to. Then that can be used against you. But again, that has to be a lawful arrest, a search warrant signed by a judge, and the sample has to be taken, by a qualified individual, and they would have to follow all the protocols like chain of custody and things like that for it to be admissible. So there's that. And a final note: um, what if you're you're the driver, you're in an accident, and you're unconscious? Can they take your blood? The answer is yes. If you're unconscious or otherwise unable to give consent, it specifies in the code, if you'll see right here, let's see, is it on that first page? Yes, under 3B, a person who is dead, unconscious, or otherwise in a condition rendering him or her incapable of refusal shall be deemed not to have withdrawn consent. So specifically says that that's okay in this case. But anyway, that's just an overview of implied consent. There's a lot of nuances to it that I haven't gotten into, such as if you're arrested for DUI on private property, say you're in a parking lot, or driving in maybe a closed subdivision or something that's private property. Implied consent does not apply there. So that's a whole separate issue in itself. But that's just kind of an overview of implied consent. Remember, this does not constitute legal advice. I'm just sort of laying out the process of the law there. If you have any questions or comments, please feel free to post them in the comment section below. Let me know if this video worked, if the sound was good, if the video quality was okay, and all that. And hopefully everything works out, and I'll be able to make some additional content down the road. All right. Well, thanks for watching.